Hello and welcome back, my dear students. Today we are going to talk about the next part of a topic that we discussed in the previous module, that is economic theory of property. That time we discussed the first part of it. Today we will be discussing the second part of this topic. Now, to introduce the topic, property as frequently considered by philosophers is a tool for pursuing basic principles. A few philosophers of the concept of property have focused on how property may promote concepts like self-expression, usage, fairness, and growth in the society. The law of every country has always been impacted by these intellectual traditions. According to utilitarians, the net happiness or satisfaction produced by an action or a good determines its value. The goal of the institution of property, according to utilitarians, is to maximize overall happiness or satisfaction derived from material and non-material resources. Property, according to Bentham, is an expectation of utility. According to him, property is simply the foundation for expectation, that is, the hope that a person benefits from what he owns because of his relationship with the asset. One benchmark that property regulations might be assessed against is the goal of maximizing total utility. In each of the previously described instances, a legal norm that aims to maximize the total benefits or pleasure of society as a whole can be established in order to decide the issue on utilitarian grounds. A person's claim to property is perceived to be transient under the utilitarian perspective. In theory, property might be seized from him if the expropriation beneficiaries benefit more from it than the loss that the owner accrues. The utilitarian theory of property has its detractors who frequently question whether the theory overly tentatively defines ownership. It questions whether ownership is only a matter of mere expectation, or if it weighs more than that, it looks into the viability of someone being lawfully deprived of their assets simply because the benefits to those who are accorded the rights outweigh the losses incurred because of the loss of ownership of the property. The mainstream economic theory, which maintains that the primary objective of property is to maximize wealth, is also challenged by this perspective of the utilitarian theory of the property. Ownership should be considered more important than only having the right to a source of income. It would somehow be irrational if the law forces someone to dispose of their property just because some people benefit more financially than the others. The concept of distributive justice attached to property is what we will discuss now. A different philosophical perspective on property law places more emphasis on the ability of the law to be able to accomplish the objective of the distributive justice better than it can help to achieve happiness or satisfaction. For instance, Aristotle believed that different types of social structures implicitly incorporate the notion of distributive justice, and the concept of justice varies depending upon the society. Nevertheless, it is more desirable for every form of society to advance its own idea of distributive justice through its legal framework, including the laws that pertain to the issue of property rights therein. He maintained that whereas an aristocracy would favor the allocation of resources based on the merits of different classes, Democracy would rather favor an equal distribution of income. Aristocrats, as per Aristotle's perception, simply receive an uneven share of wealth because they put their money into more productive uses than the ordinary individuals. Using Aristotle's perspective of democratic equality, a redistributive justice policy may be perceived to be a one in which the society's valuable assets are usually reallocated to achieve a nearly equal distribution of assets and resources. Generally speaking, this kind of redistribution would discourage the affluent and benefit the poor. On the contrary, the exact opposite context of redistributive justice implicated by Aristotle's idea of aristocratic inequality would rather mean that the resources of the society would be regularly transferred to the aristocrats. Using Aristotle's perspective of democratic equality, where the aristocrats and the wealthy people are the same, such a transfer of wealth would benefit the wealthy and penalize the poor. These interpretations of the equitable distribution of property, regardless of the circumstances, leaves the claims to property susceptible to the same criticism as they did under utilitarianism criteria. The concept of property based on liberty and self-expression. Let us discuss this now. Apart from distributive fairness and usefulness, another fundamental concept on which the property law is based is the idea of liberty. The concept of a market is based on the principle of private property, and markets serve as a decentralized method of resource distribution. A significant number of markets function well enough without too much government intervention or regulation. In contemporary economic setups, proper government planning is a more logical option than the free play of markets. The process of government planning entails the transfer of centralized control over economic issues to the state authorities. The power to control the economy also gives the government officials the power to influence other facets of the lives of the people. Nonetheless, private property establishes a realm of discretion where people are not held accountable to the state authority. Individual property, therefore, has been seen by some thinkers as a safeguard against the autocratic power of the states. For example, it has been believed that capitalism was intentionally developed to deny the king economic authority in order to fight against his absolute power. The design of the United States Constitution was most likely based on this ideology only. Now, let us move further to discuss the need for protection of property rights. Having discussed the theoretical and philosophical aspects of the concept of property, it becomes logical to understand why property rights should be protected under the law. The long-standing and fundamental question that has always arisen is, why should a thing have any kind of property rights at all? Stated differently, it means to find out ways in which securing property rights and the transfer of property foster the objective of community welfare. One argument in favor of safeguarding property rights is that it provides incentives for labor. This can be further understood from the example that a farmer would not work hard to cultivate crops if he was not allowed to retain the reward of his labor. In the same way, property rights encourage the maintenance and enhancement of durable objects such as repairing buildings, fertilization and irrigation of land, and the conservation of the supply of renewable resources as well. Property rights are further justified by the fact that in the absence of these rights, people would more often engage in conflict and waste time and resources trying to steal goods from other people or keep busy safeguarding the things that they own themselves. Even if it comes at a cost, the state's participation in the protection of property rights will help to minimize these major disadvantages that would result from the lack of enforcement of property rights. One additional advantage of defending property rights is that it safeguards people and protects them against any danger. People would risk having their possessions stolen if there were no protection for property rights. They might also benefit from the likelihood that they could take over someone else's assets. Furthermore, it is essential that there exists a framework of property rights that leaves scope for the free transfer of goods within the system itself. More explicitly, if the trade of goods is permissible, goods will quite often be distributed to those who value them the most. The ability to exchange goods is indirectly required for deriving benefits from the economies of large-scale production and division of labor. This is because when a single entity produces goods in a large quantity, the output must eventually be distributed or transferred to many other people too. Moreover, the company has to depend upon other parties to meet their needs for inputs for production. Additionally, the ability to transfer property, specifically land, renders it useful as collateral, which facilitates the functioning of credit markets as well. The early proponents of property rights, such as Hobbes, who gave the concept in the year 1651, Blackstone, who studied it during 1765 to 1769, and Bentham, who worked on this concept in the year 1830, emphasized the need for providing incentives to labor and hence avoiding conflict. In the contemporary regime, the benefits of property rights are either referred to more casually or are taken for granted. Moreover, they are usually confused about the problems pertaining to the capitalistic structure and private property. This, however, is wrong because even a centrally planned economy can offer all the benefits of property rights as we discussed earlier. For example, making payments to the workers according to their contribution to work might encourage them to work even if the output is owned by the public authority. Further, I am going to discuss the evolution of property rights. When the numerous benefits of establishing property rights significantly exceed the costs of developing and protecting the rights, property rights can be expected to evolve either from a background of absolutely no rights or simply poorly developed rights. Under such circumstances, property rights are more likely to evolve because if a large number of people realize that the enforcement of such rights will rather put them in a better off position, then this will create a pressure on the system for the application and establishment of rights that safeguard their ownership over their assets and resources. Numerous instances of the evolution of property rights have been explored in the past. Property rights during the California gold rush were examined by, do you know whom? Umbeck in 1981. Property rights over minerals and land were essentially not defined when gold was discovered in California in the year 1848, and there was hardly any statutory body to implement the law at the time. However, Plans were put in place immediately to safeguard property rights in riverbeds and areas rich in gold. This deterred futile efforts made to seize gold and land from one another, but encouraged people to build sluices, pan for gold, and make other investments in the gold mining industry. Sea resources, do you know, are a more recent example of the formation of property rights, as was noted by Eckert in the year 1979 and Biblowit in the year 1991. Fish populations have been reduced by the use of modern fishing techniques, yet throughout most of history, no property rights have ever been assigned to the fisheries available in the oceans just because it was believed that the supply of fish was nearly infinite. It has now become largely established that nations own property rights over fish found in their coastal waters, which serves as an incentive to protect the fisheries. Recently, property rights have also been established at the bottom of the ocean in order to facilitate the discovery and extraction of mineral and oil resources. Further, I am going to discuss the division and distribution of property rights, how this functions. From a theoretical perspective, the rights that are usually referred to as property rights in a rather vague sense may be separate into two more fundamental rights, that is, the right to a particular ownership and the right to pass on or transfer these rights. The right to use something in a particular manner at a specific time and in a specific situation is referred to as a possessory right or the ownership right. Giving or selling off the ownership right to some other person is known as the right to transfer the property. Therefore, what is generally understood to be the ownership of a resource like land comprises both a wide range of ownership rights, including the ability to construct structures on the land, cultivate it, etc. in most situations, and for all times to come, also the related rights to transfer them. Property rights in the case of goods are actually typically held in highly aggregated bundles, but in present day circumstances, there is also a large division of rights based on time and circumstances. Whether the rights are possessory rights or are transferable rights, etc. For example, a landowner may not have complete rights of ownership if someone else possesses an easement over the land, granting the landowner access to his property, the ability to harvest wood from it, or the ability to extract oil in case it is discovered on the same land. While wills usually offer a future conditional distribution of rights that is dependent upon the survival of the inheritors, leasing contracts represent a split of property rights over time. In situations where an adult is assigned the responsibility of supervising the property on behalf of a minor, trust arrangements also divide property rights into two categories, the possessory rights and the transfer rights. When various parties gain from ownership rights in different ways, it can prove to be more beneficial to allocate those rights because benefits can be realized only if those who gain the most from these rights are actually accorded rights over that property. However, there are a number of limitations as well associated with the distribution of property rights or with regards to dividing these rights too precisely between the individuals. Furthermore, issues pertaining to operational feasibility might also render the allocation of rights difficult. It is also important to note here that possessory rights and transfer rights are typically combined because that leads to an increase in efficiency. The owners of property rights usually have better knowledge of which opportunities for the sale of assets are more profitable. Also, if the owners know that they will be able to obtain profits from the sale of assets, they will make the right decision regarding their investments in that property. Separating the rights to transfer a property from ownership rights, however, at times becomes more beneficial. For example, a renter of a flat might not be granted the right to further rent it out because he does not have an adequate justification to take another tenant's personality and reputation into consideration. This can be understood from one more example, that is, when a child possesses ownership rights over a property but does not have the right to transfer it to anyone because an adult trustee who is maturer and superior in judgment has been assigned the power to oversee the decisions pertaining to the sale or transfer of the property. The next part of the topic is a consolidated form of property rights by a firm. Consolidated ownership refers to the holding of various productive assets by a single organization or a company. It was Ronald Coase in the year 1937 who for the first time delved into the benefits that this type of ownership entails. However, various other scholars and researchers, including Williamson in the year 1975 and then in 1985, Klein, Crawford and Alcuin in the year 1978, Grossman and Hart in the year 1986, and Hart further in the year 1995, contributed towards its subsequent refinements. The key elements that influence the relative benefits of business entities retaining their assets either independently or in an integrated form are being dealt with further in this module. One advantage of consolidated ownership of assets is that it lowers the transaction cost by removing the need for negotiation and bookkeeping expenses when internal transfers of the products and services may be completed by command. However, independent proprietors may commonly achieve this kind of reduction in transaction cost if they establish long-term supply agreements, comply with scheduled orders, or make other similar arrangements. A second advantage would be compared to a system where each person owns the asset that are utilized for production, aggregated ownership may result in a decline in the incentives for work. Business organizations may address this motivation problem in two popular ways. If they can monitor the performance of the workers, they can penalize the shirking behavior as well, and if not, they may connect income and salaries to production metrics. Both approaches, of course, have their own demerits. It is interesting to note here that the latter might induce transaction costs back into the process if, for example, transfer pricing is needed to determine how much the manager contributed towards the profits for the company. Another advantage is that since the integrated ownership may eliminate asymmetrical information, it may lead to failures in the bargaining process in the case of a separate ownership. For example, in a situation where ownership is separate, the seller of a factor of production may assess the value of the factor input higher enough for the next stage producer and hence charge exorbitantly for the service, thus impeding efficiency in the transaction. It is possible to schedule efficient transfers under the consolidated ownership. Conversely, independent owners of factor inputs can agree in advance to allow a transfer of their service to take place for a fixed price. One more merit of this criteria is consolidated ownership has the potential to mitigate the issues associated with insufficient investment in assets. It is possible that the owner of an asset lacks the requisite motivation to upgrade the investment, which is relationship specific in nature, simply because he believes that when he goes to utilize his asset, the owner of a complementary item will partially expropriate his gains. However, the entire issue of expropriation of the profits from the relation specific investment in the first asset would be resolved, and investment in it would turn out to be beneficial if both the assets are owned by the same party. Now, let me conclude my entire lecture. Philosophers view the property concept as a tool for pursuing basic principles like self-expression, usage, fairness, and growth in society. Property law is based on the principles of liberty and private property, allowing for decentralized resource distribution. Protection of property rights is essential for community welfare, providing incentives for labor, minimizing conflict and theft, and allowing free transfer of goods. Early proponents of property rights like Hobbes, Blackstone, and Bentham emphasized the need for labor incentives. Consolidated ownership refers to the holding of various productive assets by a single organization or a company. It has been studied by philosophers and scholars like Ronald Coase and Hart. Consolidated ownership can mitigate issues associated with insufficient investment in assets, as it resolves the issue of expropriation of profits from relationship specific investments in the first asset. With this, we come to the end of today's lecture. Thank you very much.